Yo, mema mo akwa abastronko so aba POG Media so message sa fee and I said what about Jumadian so I subscribe like it to Jumadian share nema for friends so and can be kindly click on the notification bell so send be yeah the any news be at a platform so I want so no dear echo and the eba you Ryan seminum na yendo in seminum esukwa hey Justice Torkono former Chief Justice the near the mean just say I am also on crowd and you may be a air qua just say anya de NPE. Na yeah him say enche during last na say air back Thursday, Friday and ebetu just say mami at the akoko to say a vet number vet say a year Odonyam for justice a year Baffoe.B no on in the Chief Justice a rule no. Yeah all say a year program no and I say any day side you may na amaso. The saint die no one in some of the according codes. Now we and Abidja Fortuna say na omobo boy and some no home are lawyers for kukudam. And this story is very interesting because obesuya law no you feel the law. So what I say you feel the law because there was Martin Pepu or Tamaklu and Braco Powers or lawyers for Kukudamwa. They were all deliberating on this issue. It was a very interesting conversation. And we and people kasana or raise the able to say maame no do say kwan bi wo aye de ne air faswa the grounds for removal no very solid but say prima facie no maame no ye man nya a reason there eno de enya kwan papa no obefo aso na emre bi atwam ye de bi edi chachichu kata ema eno no na nsensem bebre nti all day Tr0ublė in summer of mu in 2003 case no eba be linking to what is happening now and also Ghana yeah sa neoma we no ebe continue on because it's been 22 years and I say a time will come on onim say be or no say be hwan na aside repeat which is not a good precedent and you saw a Tr0ublė case and Tr0ublė what he went through that time na just say onu say it was unfair a judgment to Tr0ublė no and odi making grounds on Torkono na all kinds and along the line no tamaklu and so be de ebe remu lawyer tamaklu or so be de ebe remu and the nsem etutu dwa enye easy if you hoye de yanko na yankonkuti ensem e call so subscribe like to Jumadi yanko ni gonkuti.
Why that's it. Unless it's so egregious.
Because I'm asking myself.
Unless it's so bad, what went on there is so bad that no human institution will countenance it, then that's how she can win. But with what we've seen, there are a few problems. I think, look, in all of this, what she has most going for her, in my estimation, is the failure of the president to give the reasons for the prima facie. Yes, that's one.
That's the subject matter of the judiciary.
No, she's raised it. Hey, let's go.
Sina, if you look at
wait, I'm paraphrasing. So let me show you. Let me show you why she's raised that one there. It will come to haunt us for years to come. Because when that was done to Tr0ublė, we're up in arms that the judiciary didn't do well. They didn't do well, okay? They didn't do well because the Supreme Court itself, when Tr0ublė was not given the prima facie thing, the Supreme Court itself said the trial judge's failure to give the reasons for the prima facie ruling just shows bias, malice, thoughtlessness. Yes, after saying all that, at the end of the day, they say, but it's not sufficient to cancel the whole trial. So as for, and that's 2003, 2004, Tr0ublė's case. 2003, 2000. So the Supreme Court itself haven't set that standard that if you don't give reasons, you give way for people to think that you are biased, you are thoughtless, you are malicious. I thought that this one, we should have done it. So as for the failure to give Torkono the prima facie reasons, it's bad. It's bad in this process.
No,
but
I
it is not sufficient.
Senior, with respect. No, but Senior, you see the reliefs
Which
here.
one? No. And I'll justify, okay, you read.
Yeah, so Senior,
hold on.
I listen there.
No, the reliefs.
The specific reliefs,
says, please take note, so.
Yes.
For the following reliefs.
Yes.
A, an order of T0urt bringing up into this court for the purpose of being quashed and for quashing the proceedings of 15th of May 2025 and the entire proceedings and the outcome of the Article 146 set up to consider petitions to remove the applicant, chaired by Puama JSC, that's relief A. B, an order of certiorari bringing up into this court for the purpose of being quashed and for quashing each and all of the 3 reasons and grounds given. So grounds and reasons.
Yes. But if not, so when you read it, so now
and so if you go through all the reliefs, she had never questioned, for the purpose of this judicial review, the fact that the prima facie was without reason. In fact, she herself says reasons. Please, with respect. It's not here. At least for this judicial review. Unless, of course, it's a different process. If it's a different process, that's fine.
Let me respond. Please, when you read it, she tells you that that is the foundation. We can get the paragraphs. So what you are reading is the top. It's in there. She says,
reliefs.
Yes. So she's saying that, you see, in law, what she's saying is that in law, you can't put anything or nothing. It will collapse. Baffoe versus UAC. So lawyers, so she's saying that there's, I read it. ADJ also read it. So she's saying that the relief is the final outcome. Why is she asking for the relief? The reason she's asking for, she says you have no foundation. So anything you put on it will collapse. That's what she's saying. There are several paragraphs where she says she was not given the reasons for the prima facie. So her case is that once she doesn't have the reasons for the prima facie, you can't even do the hearing. And I'm saying that one she won't win, because in the same T.Tsikata case, what they did was that they just berated the trial judge for not giving the reasons. But they said it's not sufficient to cancel the case to say, Tsikata, because you were not giving reasons for prima facie, walk free. And that one was even a criminal trial, where Tsikata's
liberty
excellent. So that one was a higher things were at stake, liberties, right? Personal liberties. Yeah, the Supreme Court said when Justice Henrietta Aban didn't give reasons for the prima facie, though it was bad, it was thoughtless, it was malicious, it showed bias, etc. But still, the fact that Tsikata should open his case was a good decision. It should stand. And then, ADG yourself, you've been citing the other case, 2017. Is it
Michael Asamoah?
But yes, so you also have it. So she will not win, but that one, it will come to haunt us for years to come. That if in 2003, 2004, we said failure to give reasons is bad, it's not good for our governance, why are we repeating that in 2025? That's a separate argument, but that's not sufficient for her to win the case.
Okay.
So let's go on. So now the thing is that, so when you
can I chip something? No, just chip something.
Unless that is on the permission of
Matibebo. Sina, with respect to enrich the conversation.
Yes.
You see, she grounds the reliefs, the 4 reliefs, on specific grounds.
Yes.
And the grounds start from Roman numeral 1 to 10.
Yeah.
Each one of them, it is in respect. So, for instance, ground 1, that all of the alleged findings, and ground 4, recommendation of the committee set up by the president, not the prima facie. Roman numeral 2, the findings and recommendations of the committee. 3, the first alleged finding and recommendation. 4, the first alleged finding and recommendation of the Puaman. So throughout, the attack is the Puaman committee. The findings and recommendations. Findings and recommendations. In fact, there is no specific instance that she even brings up the issue of the prima facie determination by the president and the Council of State. And I am making
several paragraphs. When
you read affidavits is there.
Judicial we are doing law with respect to you. A judicial review has reliefs and grounds.
You've had your so let's go. Look, even before paragraph 94, before paragraph 50, she raised it. But look, another lawyer who has read it says we should start with 94. So let's go to 94 and come. And I'll tell you that before 50, I read it. So let's go straight to 94.
So 94, where exactly are you looking at?
94, I'm just scrolling. Don't say she
No,
didn't
it's
raise
94.
it.
Just look at
It's
94. That the proceedings, the refusal to give me a copy of the alleged prima facie determination. That should have determined what case I was to answer in the proceedings. And the current refusal to also give me a copy of the alleged report allegedly recommending my removal from office as Chief Justice. And the alleged reasons communicated by the Secretary of the President as the reasons given by the Permanent Committee for recommending my removal as Chief Justice from office show a reckless disregard for my rights as a citizen to procedural and substantive justice. And a total lack of any reasons for removing me from office as Chief Justice found in the petitions referred for hearing, and an insistence on presenting any sham excuse for removing me from office while hiding behind the veil of in-camera proceedings, and a refusal to give me a copy of the report as if I do not merit the minimum humane treatment of even being given a copy of the record explaining the reasons for taking my rights and entitlement for me. So after that's the paragraph.
And before that, even before paragraph 50.
Martin,
but she has said that.
Martin, can I quickly, can I just clarify a few things?
So,
Let me
so
clarify. You see, when you do a judicial review application, you look for two things, two substantive things, the reliefs and the grounds. The affidavit provides the factual matrices. At this point, what the court is called upon is to give you something, and that is what the relief does. The grounds provides the legal basis why you are seeking for those reliefs.
Oh, yes. So that's
and the grounds, Senior, can you point out where in any of the 10 grounds formulated that she challenges the prima facie determination? If you do that, I would yield to you.
So, perfect. Now let's go.
Help me out.
Let's start. Let's start. Paragraph 34.
No, reliefs. I say reliefs and the grounds.
So when I get to the grounds, I'll show you where she said there's an aberration of Article 19, Clause 13 and 23. That's what she's referring to. That she's not had proper justice. 19, 13, and then 23. You see, let's get this. The fact, I've been very clear that the removal is correct.
No, I'm not even disagreeing with you. I'm just saying that we should put the law.
View. Even this is what I'll say. Even if I went to the Supreme Court, this is what I'll say.
I don't disagree with you.
Of a removal, I support it 200%. Okay, it's just that the process you couldn't have gotten 100%. Look, if you want to understand this thing. All of us seated here, even including the professors, how many times when you were in university did you write exams and you got 100%? You won't get 100. So that is the principle we are showing, that the little things that went wrong. But we are not saying it's a failure. It's just to show that the committee couldn't have, the president didn't get 100% in the process. And that one we have the right to show, because it's not good if in 2003, 2004, the Supreme Court said if you don't give reasons, you appear biased, you appear thoughtless, you appear malicious. We shouldn't do that more than 25 years on. We shouldn't do that. That's the point I'm making. But it doesn't mean her removal is correct. No, that one, even if I was called in the Supreme Court, I'm sure I can justify my position. That they themselves said it. And so today, you won't find the Supreme Court to say failure to give Torkono the prima facie ruling is good. The Supreme Court would never be able to do that, considering their own decision in the Tr0ublė case. And the whole nation was behind Tr0ublė, saying that, why did the trial judge fail to give Tr0ublė reasons for saying he should open his defense? So if more than 20 years ago, the whole nation was supporting Tr0ublė and they said, how can it be right now, more than 20 years on, that, failure to give Torkono reasons is kosher? We can't do that. We will not do that. Even the Supreme Court itself cannot do that. Except that
cannot do what exactly?
Cannot say that failure to give Torkono reasons is good. That's the point I'm
Senior,
making.
once again, the injunction application, read my Lord Justice Tanko's view, and let me read it. In the injunction application, no, please, can I read? Hold on. The ruling of Justice Tanko.
Yes.
on the injunction. She raised the specific issue of she not being given the reason for the prima facie. And this is how my Lord Justice Tanko canvassing all your grounds. He said, quote, the next ground on which the applicant invites the court to restrain the committee is that the prima facie determination was not judicious, as it was rendered without reasons. I have cautioned myself against prejudicing the substantive relief sought in the action. However, it is not in doubt. The applicant herself has acknowledged the existence of a prima facie determination. She herself has acknowledged the existence of a prima facie determination, however described. Then he proceeds. Whether the form or content of that determination rendered it a nullity due to the alleged absence of reasoning is a matter to be determined at the substantive matter.
Yo, go to our Jumedia, subscribe, like it to Jumedia, my share them out for friends and kindly click on the notification bell so send any news be out to platforms and so on. Also, one the air call and the air POG Media, the POG Media, the Jumedia no ebe bremo amamunina so many yanko near Concoje a family and someone ever.
But I'm saying in this matter, that's not what she had raised. This is the injunction matter. You know it. I don't have a problem. If you are saying that going forward, we should add that to what we do. It's a different matter.
I think that you see,
it's not part of the ground.
Responding to an issue that he raised.
Yes, so you reinforce what I've said.
I don't think so.
You see, I told that
you wanted to make it, no, you wanted to make it look like it was part of the judicial review.
He couldn't have said the figure is correct. He says it falls to be determined.
No.
Yes.
Read the whole thing.
So now let's go to 34. 34 says that my position is that having been directed to hear 3 petitions on 1 warrant, following 1 purported and yet to be given prima facie determination of the 3 decisions, the committee could not unilaterally determine that its mandate was complete, blah, blah. I told you, there are at least 3 paragraphs. That's 34.
But you see, you are reading affidavit as grounds. How can you do that?
I'm going, you haven't noted that.
No, but how can you do that?
Infelicity of counsel.
That, no, senior, when you formulate grounds of a judicial review, and you give relief that you are seeking based on the formulated ground.
Yes.
You cannot use an affidavit to substitute for a ground.
You can do
I don't think we'll settle this on this matter.
Yes, I mean, we can.
I don't think we'll settle
So now let me continue. Where APG is coming from, he is talking about infelicity of language or infelicity of the language of counsel, and that place is a slippery slope. We all make mistakes. Look, some of the cases we take to court, you know, in a rush, sometimes you write certain things, not leaving court.
I don't even blame the lawyers.
Look, things happen, You look at this and say, really, did I write this? You look at the grammar, the syntax. So please, we are looking at the substance. Once the court finds, and I told you that before paragraph 50, I noted it. You see, I've read 34 to you. There are 2 other places she complained about the prima facie. It's the kernel of Torkono's case. I'm telling you,
come from different angles.
It's the kernel of Torkono's case, and that one there, she can beat it for 100 years to come, and she'll be right. We'll be supporting her just as we're supporting the T.Tsikata case. We will be supporting her so that next time the system will do better. Because look, even Nebuchadnezzar, Akuffo, he brought out his ruling. Okujeto said that this why did he say so?
No, let's not dwell on. You could have said it without necessarily referring to it.
So let's make the point. Peku has a petition for the removal of the same Torkono. Okujeto came on air and said he wrote the prima facie ruling. He wrote it very long, copious. Okujeto, he said he wrote it and Akuffo signed. So we too, you have many lawyers in the NDC. This could have been done.
What?
Writing the prima facie ruling for President Mahama to sign.
I find it extremely uncomfortable when, with respect, an impression is created that the absence of a prima facie, should I say, a reason.
Yes.
Prima facie means there was none. At least I just showed you where in the judgment of the court, the ruling by His Lordship Justice Tanko, he says that there is no judicial pronouncement or judicial authority to say that once you do that, the work of the committee is what? Is a nullity. If the work of the committee is not a nullity, and the committee has proceeded, not only that, giving her the right to be heard, appeared with her lawyers, it had gone through the motions, come to the conclusion and recommended her removal. Why are we going back to this belated? This can be the questions of. It can be the questions of reform. It can be the question of reform.
Like 3 times.
It should be a question of reform.
So now we've shown you the
If you want reform, say it. But to try to.
Hold on.
The process couldn't have been 100%. That one will say it loud and clear. Torkono, the process of the Puaman committee, it's not 100%. That one, nobody can stop us from
Was
saying.
the prima facie part of the work of the Puaman committee? No.
She's saying that so the committee should have said, Madam, if you don't have the prima facie, then we will wait. Let's
give you the opportunity.
Yes, please. Okay. That one nobody can gag us. The fact that we support the removal doesn't mean we support everything willy-nilly. Because tomorrow it could be me. Tomorrow they say, because you just thought that the grounds are strong. You see, let's not make a mistake. As for the grounds for her removal, they are very strong, very, very justified, 150%, or like 200%. But as for the process, the prima facie, there I'll be consistent. Exactly. The failure to give a prima facie, it's not kosher, it's not on. Let's not repeat that next time. Now let's go on. So you have shown paragraph 94, 30. Is it 34? I read the one we read. There are 2 other paragraphs. Yesterday I remember reading them before paragraph 50. You see 2 other ones. Now, let's answer you when you said the grounds. Where in the grounds? Do you see the grounds? The ones talking about violation of article. Look at 8. The entire proceedings and grounds of the said Puaman committee for removal of the Chief Justice from office are a violation of the applicant's constitutional rights contained in Article 19(3) and 23. That is it. So she's saying...
Who determined the prima facie? Whose responsibility?
Assuming... It's the president. So she's saying that when she didn't get it. She's saying
I just read what she read.
Yes, she's saying that when she didn't get it, and you, the committee, you were constituted, you were to ask the president to bring it forth, let her see, and then you, the committee, would also see. So that one, let's not take it. The fact that the removal is correct doesn't mean everything was correct, because we don't want this thing to repeat itself again.
So these are for reforms.
Thank you.
That is clear. These are for reform, but it does not in any way undermine what has been done.
It does a certain extent, but not sufficient to remove it. Did you get the point? It undermines the process a bit, but it doesn't meet the threshold to say that the removal is illegal.
Just
as in the T.Tsikata case.
These are policy issues.
No, it's not policy. It undermines the process a bit. But in the T.Tsikata case, the Supreme Court said, when Justice Abban Henrietta didn't give you the reasons for saying you should open your defense, it was thoughtless, it was malicious, etc. But it's not sufficient to say T.Tsikata walk free. So in the same way, Torkono is saying that when the committee didn't help her to get the prima facie ruling, they failed. They couldn't have built anything. And we are saying, no, she's wrong. She's wrong. The grounds are good enough to remove her. But that failure to give the prima facie, please, let this be the last time. We can't do this. 20 years, 2003, this is 2025. So about 22 years on, we are not learning. What does it take to write a prima facie rule? Akuffo wrote one for Akuffo, and he signed. So NDC lawyers, and they more than 200, maybe it's a small number. You could have gotten one lawyer to write it quickly, and then President Mahama signs. Okay. Yes. So is that okay, you no problem.
Any other Jumadian NBC at the message subscribe, like it to Jumadian, share them out for friends, and can kindly click on the notification bell so send any news we are on at a platform. So I want so who the echo and the about POG Media, the more POG Media, and Yakasi about some money the Yaba, say about some Ghana Punto Ghana Koso Ghana Yedi, Ninana Ope, a home a Yedura, I ha, and I'll be the Ubu POG Media, Yenama Cram.